Convention on the Rights of Persons with Disabilities was adopted at the United Nations General Assembly in 2006. Its aim is to realize a society where persons with disabilities around the world can live equally in all areas, such as education, employment, and social participation, obligating each country to provide reasonable accommodation. This convention is groundbreaking in guaranteeing the human rights of persons with disabilities. Japan signed the convention in 2007, but ratification was delayed until January 20, 2014, making it the 140th country in the world to do so. Subsequently, it was promulgated on February 19 and came into effect as domestic law, but in reality, the situation in society and the judiciary remains far from the ideals sought by the convention. In particular, the delay in accommodating persons with disabilities in Japanese courts is serious. The submission of complaints is still, in principle, on paper, and multiple copies and stamps are required, which creates extremely high physical and psychological barriers for persons with disabilities. Although electronic application has been partially introduced, the system is far from being easily accessible for persons with disabilities. Even in labor tribunals and applications for provisional dispositions, it is hard to say that reasonable accommodation is sufficiently provided, and there are situations where it is difficult for persons with disabilities themselves to access the judiciary to protect their rights. In this paper, while reviewing the establishment of the Convention on the Rights of Persons with Disabilities and the process of Japan's ratification, we clarify how the essence of reasonable accommodation is being neglected in judicial practice. Furthermore, we discuss the supremacy of international law based on Article 98, Paragraph 2 of the Constitution, and the social impact of a state of treaty violation. Finally, we present future challenges and recommendations, and together with readers, consider how to realize a society where everyone can access justice equally. The Convention on the Rights of Persons with Disabilities, official name, Convention on the Rights of Persons with Disabilities, was adopted at the United Nations General Assembly on December 13, 2006. This convention is characterized by its departure from the traditional welfare/protectionist view of persons with disabilities and by positioning persons with disabilities as subjects of rights, that is, as subjects who choose their own lives and participate in society. In the process of formulating the convention, organizations of persons with disabilities from various countries around the world actively participated, and under the slogan, "Nothing about us without us," a framework for effective rights protection was pursued. The content of the convention covers a wide range of areas, guaranteeing the right of persons with disabilities to live equally with other citizens in all fields, including education, employment, medical care, access to justice, political participation, and support for independent living. Among these, the obligation to provide reasonable accommodation has greatly advanced the global movement for the protection of the human rights of persons with disabilities. Reasonable accommodation refers to making necessary and appropriate adjustments or changes according to individual circumstances, and refusing to provide it is regarded as discrimination. Reasonable accommodation means enabling persons with disabilities to exercise their rights equally with others. Japan has participated in international discussions since the establishment of the convention, but due to delays in domestic law development and social consensus, ratification was significantly delayed. Although Japan signed the convention on September 28, 2007, it was necessary to develop the Basic Act for Persons with Disabilities and the Act for Eliminating Discrimination Against Persons with Disabilities for ratification, and coordination continued among the government, parliament, and related organizations. With the development of domestic law finally completed, ratification took place on January 20, 2014, and promulgation on February 19 of the same year, making Japan formally obligated to the Convention on the Rights of Persons with Disabilities as a member of the international community. However, the delay in ratification also symbolizes Japanese society's passivity toward disability policy and its shallow understanding of rights protection. Even now, more than 10 years after ratification, the ideals of the convention and the essence of reasonable accommodation have not sufficiently permeated Japanese society, especially in the judiciary. The convention is not just a formality, but a powerful tool for transforming actual systems and operations, as well as people's awareness. In reality, however, The content of the convention is often reduced to a mere formality, and there are many situations where the rights protection of persons with disabilities is neglected. In the next chapter, based on such realities, we will further examine the nature of disability discrimination and reasonable accommodation in Japanese society. The provision of reasonable accommodation, emphasized by the Convention on the Rights of Persons with Disabilities, is not merely goodwill or special treatment, but a right for persons with disabilities to live equally as members of society. However, in Japan, it is hard to say that the essence of this reasonable accommodation is sufficiently understood. In many cases, responses to persons with disabilities are treated as exceptions or benevolence, and there is a reality that society and organizations do not recognize that they should proactively take responsibility. For example, there are still many barriers that persons with disabilities face in public transportation, public facilities, and corporate workplaces. When wheelchair users try to access station platforms, for instance, the absence of elevators or the refusal of workplace accommodation requests on the grounds of interference with business operations are issues that continue to occur. These situations not only close the path for persons with disabilities to participate in society by their own power, but also foster the mistaken perception that disability is an individual's problem. The essence of reasonable accommodation is not that it cannot be done because of a disability, but is based on the social model that society and the environment create disabilities. In other words, many of the difficulties faced by persons with disabilities are caused by physical, institutional, and attitudinal barriers, and it is society's responsibility to remove or mitigate them. However, in Japan, the misunderstandings that accommodation is goodwill or a special burden remain deeply rooted, and persons with disabilities who seek reasonable accommodation are sometimes criticized as selfish. Although legal frameworks such as the Act for Eliminating Discrimination Against Persons with Disabilities and the strengthening of employment obligations for persons with disabilities in companies are progressing, it is hard to say that implementation and awareness reform at the practical level are sufficient. Especially in the judiciary, there is a strong tendency for accommodation for persons with disabilities to be postponed for reasons such as no precedent or procedures will become complicated. This reflects the fact that the essence of reasonable accommodation, which should be legally kaku,